Hello and welcome to the channel. An appeal court sitting in Abuja has just passed verdict on a suit presented before it to disqualify President-elect Ahmed Bola Tinubu. Who did the judge rule in favor of? Get that and many more on Apple Line Media. Subscribe, like, share, and comment. Thank you. Appeal court reserves verdict on bid to disqualify Tinubu Shettima. The Abuja Division of the Court of Appeal on Thursday reserved its judgment on a suit the People's Democratic Party (PDP) filed to disqualify the president-elect Bola Tinubu of the All Progressives Congress (APC) and his running mate Kashim Shettima. A three-member panel of justices of the court adjourned to deliver its verdict on the appeal marked CA ABJ CV 1082023 after all the parties adopted their final briefs of argument. Specifically, PDP, whose candidate Atiku Abubakar came second in the presidential election that held on February 25th, is contending that the APC candidate Tinubu, who was declared the winner of the presidential contest, was legally ineligible to participate in the poll. It told the court that the manner the APC and Tinubu nominated Shettima as a vice presidential candidate for the election was in gross breach of the provisions of sections 29, 1, 33, 35, and 84, 1 and 2 of the Electoral Act 2022 as amended. According to the PDP, Shettima was nominated twice, both for the vice presidential position as well as for Borno Central senatorial seats, an action it argued contravened the law. Aside from asking the court to nullify Tinubu and Shettima's candidacy, the appellant further sought an order to compel the Independent National Electoral Commission (INEC) to expunge their names from the list of nominated or sponsored candidates eligible to contest the election. PDP prayed the appellate court to set aside the January 13 judgment of the Federal High Court in Abuja, which dismissed legal issues it raised against the candidacy of both Tinubu and Shettima. It argued that Justice Inyang Ekwo of the trial court erred in law and arrived at an unjust conclusion that paved way for the two respondents to participate in the presidential election. Both INEC and APC were equally cited as respondents in the appeal. It will be recalled that Tinubu and Shettima had in a joint preliminary objection filed challenged the competence of the suit and the jurisdiction of the court to entertain it. They contended that PDP was bereft of the local standing legal right to institute the action against them. The duo maintained that no portion of the law conferred on the PDP the right to dabble into the domestic affair of another political party, especially on the issue of the nomination of its candidate for an election. They argued that the opposition party failed to disclose any reasonable course of action, adding that issues the PDP raised in the suit were non-justiciable. In his judgment, Justice Ekwo upheld the preliminary objection and dismissed the suit for lacking in merit. Besides, he held that the case was caught by the principle of estoppel, as the issue that was raised against the Tinubu and his running mate was previously decided by another court. Justice Ekwo held that the suit was an abuse of court process and as such deserved to be dismissed, adding that the court lacked the jurisdiction to entertain it. Subscribe, like, share, comment, and please turn the notification bell on. Thank you. In other news, the Federal High Court sitting in Abuja yesterday ordered the Independent National Electoral Commission (INEC) to allow electorates with temporary voter cards (TVC) to participate in the governorship and National Assembly elections billed for March 18. The court made the order following a suit that was brought before it by two aggrieved registered voters, Kofo Worola Olusegun and Wilson Allwell, who lamented that despite their effort and repeated visits to INEC office, they were unable to obtain their permanent voters cards (PVCs) before the February 6 deadline. The plaintiffs in the suit marked FHC ABJ CS 1802023 prayed the court to compel INEC, which was cited as the sole defendant, to allow registered voters that were unable to collect their PVC before the expiration of the deadline to vote in the elections. They maintained that unless the courts intervened, many duly registered electorates will not be able to perform their civic duties. Even though the suit, which was filed before the presidential election held on February 25th, was accompanied with an affidavit of urgency, however, the court delivered its judgment on Thursday. In its judgment, Justice Obiora Egwuata held that evidence before the court established that the plaintiffs were duly registered with their details captured in INEC's database. Consequently, he issued an order compelling the defendant, INEC, to allow the plaintiffs to vote using their temporary voter cards issued by the defendant, the plaintiffs having been duly captured in the National Register of Voters database, as well as a declaration that the plaintiffs, having fulfilled all necessary legal requirements to register and having consequently been captured in the defendant's INEC central database and manual, printed paper-based record or hard copy format of the defendant's maintained register of voters, the plaintiffs are entitled to vote using their temporary voter cards in the forthcoming 2023 general election. According to the court, neither the 1999 Constitution as amended, nor the Electoral Act 2022 emphasized that only PVC could be used for the elections. It held that the law merely stipulated the use of a voter's card. Nevertheless, Justice Egwuata declined the third party the plaintiffs sought, which was for every eligible voter with a TVC to be allowed to vote. The court stressed that it could not grant the order since the case was not filed in representative capacity. This suit having not been brought in a representative capacity, I find myself unable to grant any relief pursuant to Prayer 3 of the plaintiff's application, Justice Egwuata held. Reacting to the order, the Commission described the order as contrary to the provisions of the Electoral Act 2022 as amended, which provides that only voters with permanent voter cards (PVC) should be allowed to vote in the elections. Meanwhile, reacting to the judgment, counsel for the plaintiffs, Mr. Victor Opatola, described it as a victory for democracy, especially for Nigerians that were duly registered by INEC, but who could not get their PVCs owing bottlenecks that were not their fault. He argued that since his clients fulfilled all the legal requirements but were not issued their PVCs until the collection deadline elapsed, they ought not to be allowed to suffer injury in the form of disenfranchisement. So what the court is saying is that these two people who have fulfilled all necessary requirements can vote with their TVCs. Then by law of equity, it should also apply to all Nigerians who have fulfilled all necessary requirements and were issued TVCs by INEC, Opatola added. That's the news, guys. Thanks for listening. Until next time, bye.